rise. The Court of Appeals Division 1 is now in session.
Morning, please be seated. All right, good morning. We're here for oral argument in case number CV240509, Brooksby v. Brooksby. These proceedings are being video and audio recorded and live streamed, so we ask counsel please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
May it please the court, my name is Brian Claridge. I present my client, Barry Brooksby. Approach the podium.
Yes.
Your Honors, today on the issue on appeal is the trial court's evaluation of my client husband's business. Specifically, the trial court concluded that my client's sales ability and expertise constituted goodwill and valued the business at $1.9 million. Trial court erred as a matter of law by awarding wife a portion of husband's future earning ability and calling that future earning ability goodwill. There was no evidence at trial that the business had any goodwill. Evidence showed that he was a great salesperson, that he had the ability to close clients and sell life insurance products, which is not a goodwill, which is not a community asset. Arizona law clearly defines the difference between reputational goodwill, which is a community asset, and personal earning ability, which is not a community asset.
Is skill and experience acquired during the marriage a community asset?
It could be, Your Honor.
When is it?
A professional license acquired during the marriage could be considered goodwill. But the trial court here, we're arguing, committed an abuse of discretion. The abuse of discretion was that they applied the wrong...
You don't dispute that this is an LLC, right?
Correct.
And the LLC is a community asset?
We do not dispute that the LLC is a community asset.
Okay.
No.
And the expert used the discounted cash flow method in determining what the value of that asset was at a particular point in time?
He used the investment value and the market approach.
Okay. And the first approach takes past historical performance, normalizes it, predicts what the future cash flow stream is going to be, and then discounts that by some discount rate, right? And then maybe reduces
that is
it for
correct.
marketability or non-marketability?
Correct. What we're arguing, Your Honor, is that the expert at trial, determined that 100% of the value of the business was attributable to goodwill.
Well, are you arguing that an expert valuation can never use that sort of method when a separate LLC is basically driven by one of the spouses?
So I'm not arguing that it can never be used, but there was no distinction by the expert in what percentage of the business was goodwill and what percentage of the business was attributed to my client's earning ability.
Well, I've read the expert report. He doesn't mention goodwill at all in there.
Your Honor, he basically conflated personal earning ability to goodwill. He called it goodwill.
And you know that from his testimony, right?
Correct.
Well, his testimony was that the $1.9 million is the value of the business at a particular point in time. And at that same point in time, the business had $140,000 in hard assets, right?
Correct.
And that the difference between those two numbers is goodwill.
Correct. He also mentioned there was about $50,000 to $80,000 a year in residual income, but he did not define what the goodwill was. He did not identify that it was from repeat customers, from brand recognition, reputation in the marketplace.
Well, isn't it correct, though, from an accounting and tax perspective, that the difference between the total value of a business and the hard assets in the business is goodwill?
That is correct, Your Honor, but there was no evidence at the trial court of what the goodwill specifically was.
Well, it was the value of the future cash flows discounted by a particular rate.
That was not presented at trial.
But it's in his report, which came into evidence, right?
I don't believe he did an adequate job determining what portion of the business was goodwill.
The future cash flows of the business are attributable to Mr. Brooksby's labor, correct?
His future labor, correct?
Yes, and the expert testified to that.
That is correct.
And Mr. Brooksby's future labor is not a community asset, right?
That's correct.
So, counsel, would you say post-dissolution salary would be compensation here, husband's post-dissolution salary for husband's labor?
Could you repeat your question? I don't quite understand.
Okay, so husband's salary that he's pulling from this company after dissolution,
Sure.
would you concede that that's compensation for post-dissolution work, for labor,
For whom?
for husband? I mean, we're not talking
Yes.
about wife's compensation here.
Yes, I would concede that.
Okay. Do you have a case in which a court has said revenue generated by a close corporation is future earnings? Revenue is future earnings attributable to husband's post-dissolution labor. Do you have a case that says that?
I don't believe I do, Your Honor. But
But there's case law that says future earning capacity is not goodwill, right?
that is correct.
And there's case law that says a spouse's post-divorce labors are not a community asset.
That is correct, Your Honor. The argument is that the revenue did not exist at the time of the dissolution. It's all future revenue my client will have to earn. My client
Your
goes
client
in-
had employees though, too, right?
My client had one employee in sort of an administrative role.
Is there evidence in the record about what the employee's role was?
Yes, Your Honor.
Where?
In the transcript, my client testified that she was a receptionist, set appointments, things of that nature. She was not a salesperson. Your Honor, my client's business.
So when your client's financials have a line item for payroll, non-owner wages of $46,000 in 2022, that's for that employee?
Correct, Your Honor.
And then he paid himself, it looks like, $63,000? That's officer wages?
Correct, Your Honor. May I continue?
Yeah.
So my client was ordered to pay about $986,000 to wife out of future earnings that did not exist at the time of the dissolution. That essentially turns his future earnings that are not guaranteed, which we understand, into a community asset, which is simply not fair. If the business had substantial goodwill, it could be sold.
But it's not his earnings, it's the LLC's earnings, right? It seems like we're conflating the LLC and the
Correct, Your Honor,
individual.
but converting someone, a sole proprietor with one employee, no tangible hard assets, right? The $140,000 that you quoted, that was some money in a bank account that he had at the time of dissolution, a business bank account, and some furnishings in the office, some furnishings in his home office as well. That's all the hard assets of the business. No one is going to purchase this business for $1.9 million.
Well, Mr. Brooksby testified it was worth $240,000, so where does the additional $100,000 come from?
That would be the hard assets in the bank and the residual income, I believe, Your Honor, and the furniture. That's where I believe that you came to that number.
Do you discount the residual income somehow?
Did he discount the so every year he makes about $50,000 to $80,000 in residual income, and usually the trial court record, he testified that the residual income usually lasts for a year or two. It's a small upfront residual income on these life insurance contracts that he sells.
Who paid the expert? I know it was a court-appointed expert, although there was some disagreement.
I believe Mother's counsel. I believe Mother paid for the evaluation subject to future reallocation, which I believe was split equally. I don't know off the top of my head. I'm sorry.
So what exactly is the remedy that you're seeking?
We are seeking this court remand the case back to the trial court level to redo the value of the goodwill that was attributed to the business.
Okay, so for further evidentiary proceedings based on new evidence?
Not new evidence, but I would presume there would be a new expert that would testify to what the value of the goodwill was.
So you want a reevaluation of the business and a redetermination?
Correct, Your Honor.
Why didn't you offer that expert testimony in this proceeding?
In this proceeding, Your Honor?
That's on appeal, right? So you have a court-appointed expert who says things you don't like.
Sure.
Did that prevent you from offering your own expert that you now intend to introduce on remand?
It did not prevent me. We had someone help me prepare the cross-examination. We did not have our own expert. We don't dispute that the expert gave testimony or that he was not an expert, he was not qualified. What we are disputing is that the conclusion that he relied upon, that goodwill just existed in that gap, and he gave no value of the business to anything but goodwill, is what we are disputing.
But you're asking us to send it back down so you can introduce an expert who you didn't introduce in this, what's on appeal now.
It may not be a new expert, but I would ask more questions of the expert and trying to pin down what the value of the goodwill is, if that makes sense, Your Honor.
Well, he said it's 1.76 million, right?
He said
It's the difference between 1.9 million and 140,000?
He said it was 1.9 million, but he didn't break down. He produced no testimony of what the goodwill was. He just says, that's goodwill, trust me,
But I have
I'm
a
an expert.
50-page expert report that explains how he got to that $1.9 million number.
Does not explain any asset of goodwill. It says that goodwill exists. It doesn't say what it is derived from.
Right, but I guess, so in some ways we have a conflict between what he did in his report and what his testimony was? Is that right? Because his report explains how he gets to the 1.9 million. He takes projections, discounts them back.
Sure.
Maybe discounts
So the
that for lack
record-
of marketability. And then he explains at trial that the difference between the hard assets and the total company value is goodwill.
Correct, but the difference between the hard assets and the total value of goodwill is nearly the entire value of the business, which we believe is untenable.
Is there a difference between the value of the business and the value of the community's interest in the business? In other words, the value of the business could include future anticipated earnings from future labor that the community would not have any right to?
That's correct, Your Honor. If you look at the trial record and that expert report, 99% is a mathematical calculation of what the goodwill is what percentage of the value comes from goodwill. Nowhere in there does the expert say this is goodwill. There's no identification of repeat customers. There's no discussion of marketability, brand value in the marketplace. Perhaps the best example of why attributing...
Which to me means he didn't really look at goodwill in his report. He explained that the difference between the total value and the hard assets is goodwill. And I'm not sure that's wrong from an accounting or tax perspective. I mean, the U.S. Supreme Court has said goodwill is the excess of the purchase price over the fair value of all identifiable assets acquired.
But in this case, that would be defining, it just does not seem tenable that $1.8 million, $1.7 million is all this undefined asset. We're not saying the business...
It's not. It's the present value of future cash flows.
We are saying that the expert did not clearly define what goodwill was in the trial court level, and that the judge made a finding not sustained by the evidence.
The testimony he gave sounds a lot like what the U.S. Supreme Court said in Winstar about the meaning of goodwill, that it's the excess of the purchase price, what someone would pay for a business, over and above the tangible asset value.
And we don't dispute that definition, Your Honor. What we're disputing is that there was no evidence on the record of what the goodwill actually was that comprises 99% of the value of the business.
Okay.
So my question, I'm going to go back to, on remand. So you said you might not necessarily ask for a new expert, but you'd ask different questions of their expert, of the court-appointed expert.
Correct.
Why didn't you ask those questions the first time?
I don't know that we didn't. There's a question that I did not ask specifically. I thought he went through a robust cross-examination, but even after cross-examination, his definition of goodwill and what he supported his finding on, his recommendation, his report on, what you call it, he did not clearly define what goodwill was. He just says, there it is, it's over there, trust me, but without defining what it was exactly.
And did you break that down in questions
Yes, Your Honor.
to present,
Yes, Your
you're
Honor.
not preserving the argument, but...
Yes, we asked what the hard assets were worth. We asked what we thought a saleable price would be. On examination of mother, we asked if she was interested in buying the business. We asked if she was interested in selling the business.
So why would we send it back down for an evidentiary hearing?
To determine the correct value of the goodwill of the business.
But isn't that what the first one was for?
Correct, but it was done incorrectly. the finding that,
You had the burden to show your client had the burden to show his number. He either met that burden or he didn't meet that burden. You want us to send it back for a do-over.
those are your words. What I'm saying is that the trial court judge made a finding that was not sustained by the facts. And that finding specifically is that nearly the entire value of the business was goodwill, without defining what goodwill is.
So if that's true, then we just take husband's number of 240 and split that. We don't send it back down for a do-over. Unless you can show me some authority that says, I would ask questions I didn't ask the first time, I would introduce a new expert witness.
You could certainly introduce an expert witness if that was appropriate. And again, I'm not saying my client's business has no goodwill. What I'm saying is I don't believe it's $1.75 million, $1.75 million or thereabouts.
Who has the burden of proving what the value of the business is?
My client, Your Honor. But the trial court relied on what we think is an erroneous expert opinion because it was not, it did not sustain the findings.
If he would have said, I think it's more appropriate to use the market approach, where I go out and look at the value of other sales of the same type of business, would that have been an issue?
I'm not sure what you mean by
that. Wouldn't be goodwill, right?
I'm not sure it would be an issue, but we don't believe this business is sellable. So I don't believe it would have been an issue, no.
Well, didn't he say in his report that there was a lack of evidence about comparables?
He did say that. He did say that, and he conceded in the trial court record that my client's personal earning ability is the engine of the business, and that comprises all the goodwill.
Now, in determining spousal maintenance, the court took into account that under its orders, the wife would be receiving $900,000 for the business. If that is set aside for some reason, that also reopens the issue of spousal maintenance, doesn't it?
It could, but we are not appealing the issue of spousal maintenance.
Correct, but I understand that you may not be seeking a modification of spousal maintenance, but Ms. Brooksby might be.
It could certainly reopen that aspect of the case, Your Honor. I'm going to save the time I have left for rebuttal.
Okay, thank you.
Good morning. Michael Ellsworth on behalf of the appellee, Mindy Brooksby. There's a phrase which you may have heard, interest never sleeps. There's maybe a lesser known phrase, and maybe it's lesser known because I made it up, is neither does online marketing and agents in other time zones. So if the only thing that I get across to you this morning is that the business they are trying to describe in their opening brief is not the business that one that was evaluated or two that the court heard about at trial on that. They use in their opening brief such terms as toil and sweat, finding new clients, sales ability, cold calls. The question was asked, how many employees does the business have? On the books, as far as payment, as payroll, there was only Mr. Brooksby and one other employee. But what came out at trial and what's contained in the business evaluation was the business has agents in other states. And part of the business is to support, train those other agents. Also part of the business is our online presence. And that's why I say online marketing never sleeps. So when Mr. Brooksby in his opening brief says everything is him as far as this business, that's not what the court heard. And that's why we are saying in part that this issue about goodwill and that there is no goodwill that should be attributed because of Mr. Brooksby being the business. He is not the business. He is part of the business.
The expert, Mr. Doba, said that he didn't consider the referral sources as part of the value of the business. Isn't that true?
I believe the question asked by opposing counsel to Mr. Doba in testimony was, did he consider that? And he said, no, I did not. But he notes in his evaluation that this business contains agents in other states, and there are commissions that are generated from those.
So past referral business would have been reflected on the financials of the business, right?
Correct.
Which the expert then uses to project future cash flows. So by necessity, then that referral money is built into those projections, which he then discounts.
I would believe that is correct. Referral and/or commission. I mean, it could be, I think, either way on those. It's also noted on this issue of residual income, the $50,000 to $80,000. I believe Mr. Brooksby's testimony was that if the business was sold, those residuals would only be paid for about 3 years, but the business receives, as long as he continues to maintain the business, those residuals would come in for about 10 years. And then we look at the note, anything he's selling into the future, those also would receive residuals.
Okay, but his future sales post-divorce are not a community asset. His future efforts and income generated from his future sales is not a community asset, right?
That is correct. But
Doesn't Mr. Doba's evaluation take into account anticipated earnings from future labor?
it does from future labor, but again, we've got to figure out what is actually the labor. He, in his opening brief, he wants you to think that he's sitting on the phone making cold calls all day. That's what he portrays to the court kind of in the opening brief. But that's not the nature of his business. And we think about what did he testify to about what his business was. If we look at the transcript, he never talked about in his own testimony how much of his business is from cold calls, if he even does that. How much is from referrals? How much is commissions that he's receiving from other agents? He never testifies any of that.
There's two things your client is going to get in the future from the business. A salary, right?
My client? No.
Not your client, I'm sorry.
Oh, yes.
Opposing counsel's client.
Yes.
A salary and then some profit from the LLC.
Correct.
So the expert backs out the salary, right?
Yes.
In his report. So, I mean, in your mind, is that the personal earnings that we're talking about?
That would be reasonable personal earnings to that.
Well,
And so the income is then used to value the community asset at a particular point in time.
That is correct.
Without taking into account the salary because it's subtracted out.
That is correct.
So if Mr. Brooksby's future labor is not a community asset, except that he works as an LLC and therefore it becomes property of the LLC, and so Ms. Brooksby is entitled to half of it, is that what you're saying?
No, not half of it, because he's receiving compensation from the business for his labors. The difference here between his compensation for his labors and what the business is doing, that is the divisible asset. And as I think maybe you had pointed out without directly saying it, we understand the business appraisal was completed in October of 2023. This trial, we didn't go to trial until March, the end of March 2024. There was a 5-month period in there where the appellant had the appraisal, knew what the appraisal values were, knew what Mr. Doba's opinions were, never once took a deposition, never offered any testimony at trial regarding that, never got their own expert. And we asked about who paid for it. Initially, we had asked, the appellee had asked the court to divide that cost. And actually, I believe she had asked that the business actually pay for the cost of the appraisal. And it was objected to, so the court put that burden on the appellee to pay for the full amount of the appraisal, even though it was an appraiser that was appointed by the court. So
Didn't Mr. Doba testify that the valuation of the business is all based upon the services of a particular professional?
He did in part, but the question was asked, and I think it was said, he never mentions goodwill in his appraisal. Actually, if we look on page 2, he goes through and he actually cites Arizona law related to goodwill. The cases that have been argued by both parties in their opening briefs, Mr. Doba puts into his report and says, here's how we're viewing, or here's how we're addressing this issue of goodwill and valuation.
Shouldn't the expert at a minimum have backed out of the business's value future income attributed to future labor of Mr. Brooksby that is not a community asset?
I think he did by what they call the discount rate. And he discounted, and if you look at his report, he said I was actually probably over generous in my discount rate that I used in lowering my value to get to what I did.
Well, the discount rate was to reach the present value of the future income stream, right?
Well, I think what they do is they say, based on potentially market fluctuation, and businesses will go up and down depending on market. And you notice his report, he goes in and he talks about the economy, he talks about the economy of Arizona, he talks about interest rates of banks. He takes all these factors and he says, because of these, I'm going to discount what my appraisal value is because we may have some fluctuation.
Okay,
It's
but
going to
he
come.
never said part of the future income is future labor of Mr. Brooksby, which is not a community asset, and so therefore we're going to set aside those revenues. He never said that,
I
right?
don't think he ever said that, but he takes that into consideration of the values because of when we're looking at a profit loss on the business, in generating that, you're going to look at the income of employees. So that would have already been discounted out.
Well, how would it be discounted out?
Well, because if we're looking at what the business makes, when we talk about gross versus net profit, the business gross profit is one number. The net profit would be taking already out the income of the employees to get a net profit of the business, and then basing a value based on that net profit.
The business is not worth $1.9 million if Mr. Brooksby is not working there, right?
Well, we don't know that. And his own testimony at trial was that actually Mrs. Brooksby could actually run the business. She could go find somebody that has a sales license, and she could potentially run the business. That was his own testimony with that. And that would make sense considering that he's got agents in other states, and he's got an online presence and marketing that is looking actively for people to come in and get tutorials and those type of things. So,
In addition to the discount rate, the expert also discounted the value for non-marketability, right?
he did.
And wouldn't that take into account at least partly the risk that Mr. Brooksby would quit once someone bought the business?
Well, I think it would. And also in determining value, he looked at it and said, part of the value here of this business is what it's worth to these parties with that. Because this is a business that Mr. Brooksby and Ms. Brooksby, the appellant and appellee, had developed during their marriage, that Mr. Brooksby, the appellant, having the license, is the one who is going to keep that business and continue to work that, and that has more of a value to him than it does to somebody that may come in and want to try to take over or run the business for him. And that was also
Right, the
considered.
purpose of evaluation is to determine what a hypothetical seller and a hypothetical buyer, what price they would come to in an arm's length transaction, in a hypothetical world, right?
Yeah, having the best knowledge in an arm's length transaction, what that would be.
Right.
Yes.
A spouse's post-divorce labors is not a community asset.
It's not a community asset. So his payroll, or his what he gets as far as an income from the business as far as payroll, that is not a divisible asset.
And the efforts that he makes to make future sales is also not a community asset.
Well, that's part of the goodwill, and that's this. We're in this fuzzy area of what really goodwill is, but that can be considered goodwill, his efforts, because we look at what those efforts are. And I know in the opening brief, they use the example of somebody that's out with a paint can knocking on doors saying, hey, can I paint your house today? And that person's labors, that's not goodwill to be valued in a business. But again, that's not the business that we're talking about here. We're talking about other agents in other states that are actively working
That
and
person
creating.
went out and established an LLC, paid himself a salary, and then there were profits, he or she was married, and then gets divorced, the community would get half the value of the future income,
Well,
discounted.
discounted, correct, and that would be another analysis of saying, okay, here's what he makes, here's what the business makes, and then there's some formula that a business appraiser uses to say, I mean, we're not talking 20, 30, 10, probably 10, 20, 30 years of future income, this difference. We're talking some number. For example, I did a dental practice quite a few years ago, and if I remember right, they kind of took the income of the business times 2.5. And in that industry, that's kind of how they were putting a value on the businesses. So every business is different. But again, they had this report for 5 months. and nothing was presented to contradict the value that was put on it.
Well, Mr. Brooksby's testimony was presented.
His testimony was, I don't think it's worth that.
Well, no, he said, I think it's worth $240,000.
I don't think it's worth what the expert said. But then what evidence did he present to support his claim?
Isn't the owner of property always competent to testify about its value?
Well, yes, just as I'm competent to testify, and we see all these, see this a lot. What's the value of a used vehicle? Somebody will.
He said it's worth 240, and there's 140,000 in hard assets, so his value also has 100,000 in goodwill, right?
In goodwill.
Did he explain how he came up with that 100,000 in goodwill?
I don't believe he ever did. And then even on his own value during that, where's the residuals put into that?
Well,
there wasn't any.
Perhaps the $100,000 that is between the hard assets and the 240, perhaps that is accounting for the residuals. He was never asked that question. Perhaps a follow-up question might have been helpful, but nevertheless, although we don't know where that $100,000 comes from, we do know that the owner of the property said it's $240,000. That's competent evidence that controverts Mr. Doba's valuation, right?
Well, so then that, and that is correct, Judge, then that gets us to part of the issue here in the standard is, and in Mitchell, the Supreme Court, in citing Johnson, said, in reviewing the findings below, we review the evidence in the light most favorable to support the decision. The findings will be upheld if there is any reasonable evidence to support it. So what reasonable evidence do we have to support the judge's finding? We have Mr. Doba's report. That is reasonable evidence. And he had a chance to contradict that, and he failed to do so. And again, his opening brief wants you to think this is a business that he's out toiling, sweating, laboring, he's making cold calls, maybe he's knocking on doors to find these people. That is not this business. This business is generating for him based on what was done during the marriage, based on his education and training during marriage, based on his establishment of his online presence, based on him having agents in other states. That's helping to generate revenue here.
And all of that's goodwill.
And all that's goodwill, yes.
But it also, the value also includes, according to Mr. Doba, future efforts by Mr. Brooksby, which is not a community asset, right? And he didn't make any effort to distinguish between the two.
But some future efforts are. Him maintaining a web page, that's a future effort. Him getting up in the morning and talking with an agent in another state, that is still his efforts. And again, he's going to get compensated by his salary for those, and into the future, he is going to get more value because he's going to receive profits. Just right in time when this valuation was done, expert said, here's what it's worth. Wife should at least get this much out of it. Husband's going to get the benefit for years and years to come.
What if husband were to sort of bet on himself and he said, you know what, I'm just going to take $1 salary and I'm going to let the rest of the money reinvest it, you know, and hope I generate revenue. So the salary is $1.
Mm-hmm.
If we back that dollar out, is your argument that that is sufficient?
Well, it probably wouldn't be under that type of scenario. First of all, Judge, that's not the scenario we're talking about here, and I understand you're talking hypothetically. But then the court at that point probably could have, and or the evaluator could have, put maybe a estimated value of what his labors are in the market.
But husband didn't try to, I guess you said it didn't happen here, but husband could have normalized it, you're saying, could have offered testimony to say, I wouldn't be $1, I would be fill in the blank.
Correct. He could have said, hey, look, I've been taking less salary from the business because I have been trying to put money back into it to grow the business. But that was never his testimony. His testimony was always, this is all me, I get all the money.
Right. For purposes of this valuation, his motivation is to make his salary as high as possible because that then makes the value of the income less and the value of the business less.
It would be, but the issue is we have what he had earned over the past few years. For him to come in and say, well, I should be making $300,000
So if
instead
anything,
of...
he'd say, well, I've been paying myself $69,000, which is in the financials, but really you should put it at $150 because that's what I would get if I was not an owner. I was just the employee because someone purchased this business from me.
Yes, but he didn't even do that in his own testimony.
That was
nothing in his testimony. So they want to suggest, well, the evaluator didn't do this, this, or this. And armchair quarterback, obviously, we wish, and you probably wish, hey, maybe there was more information that could have been obtained there. But that's not what we're here about, is we're here about to look at what information was presented, what evidence was presented, and was there evidence, in that language, any reasonable evidence to support the trial court's decision? And there was reasonable evidence to support the trial court's decision, thus we must affirm at the appellate level.
Who has the burden of proving the value of the business?
Both parties do. I would suggest, when a community asset like that, both parties have that burden.
So who wins in the event of a tie?
Okay? I've had that before. We had, again, that same dental practice, we had the battle of the experts. And one expert said one value, and the other expert said another, and we had a trial judge that said something different than both of them. I brought it up on appeal because we didn't think the judge made a good decision, and the appellate court said no, the judge has discretion based on the evidence.
Yeah, we deferred to the trial court judge, right?
Correct, and that's what we did in that case. So sometimes you do have the battle of the experts.
Why can't we just send it back down and take new testimony to fill in those blanks?
Because that we're going to retry the same case that we already tried to fill in those blanks when the judge had sufficient evidence. Again, reasonable evidence. The judge had reasonable evidence to make the ruling that the judge made. So why would we send it back down? Because if we're going to do that, that's that slippery slope of, well, hey, judge, we're always just going to send it back and you get more evidence. That's not looking at what the burden of proof is. The burden of proof is, was it reasonable? And there was. If there's no other questions, I'll go ahead and finish a minute early.
Thank you.
Thank you.
Please, the court, just a brief rebuttal. Your Honor, our argument is that the expert skipped a step. He presumed most of the entire value of the business was goodwill and valued that income stream. Argument is that he needed to satisfy the legal standard of what goodwill was before he gets to that second step of evaluating it. The court should not find the law to be accounting standards, or you'd be wiping out the distinction of goodwill versus personal earning ability anytime a small business incorporates into an LLC. The U.S. Supreme Court was discussing tax basis liability, not defining community assets, and our client testified that the business had a value of about $240,000.
What is the rule you're asking us to adopt?
What is the rule I'm asking you to adopt?
Yeah, the legal principle.
The legal principle is that there is a distinction between reputational goodwill, goodwill in general, and personal earning ability, and that was not done by the trial court.
Okay.
Thanks, Your Honor.
Thank you. All right, thank you for your arguments and your briefing. We will take the matter under advisement and get you a decision in due course.